good day and welcome to the interactive session on managing infrastructure partnerships, delay, disagreement and disputes. This session is being jointly organized by International Chamber of Commerce, Young Arbitration Forum and Nishit Desai Associates. As a reminder, all participant lines will be in the listen-only mode. There will be an opportunity for you to ask questions after the presentation concludes. Should you need assistance during this conference, please signal an operator by pressing star and then 0 on your touchtone phone. Please note that this conference is being recorded. I now hand the conference over to Mr. Prateek Bagaria, Senior Member Nishit Desai Associates, who would be interviewing Mr. Chiku Mukhopadhyay, Senior Advocate, Supreme Court of India and Vice President, ICC International Court of Arbitration. Thank you, and over to you, Mr. Bagaria.
Thanks, Mazen, and good evening to everyone, and thank you for spending this time and joining us today this evening. I have with me Mr. Chiku Mukhopadhyay. He doesn't need introduction. He's one of the premier arbitration lawyers in the country, and he is the Vice President of ICC. And today we are going to interview him on his thoughts on infrastructure disputes. I think infrastructure is a sector which has a very new approach to disputes because it has new problems, it has new issues. It has very unique challenges when, as a lawyer and as a client, when you look at infrastructure disputes, especially with the kind of issues which come up in different groups who are involved in an infrastructure dispute. Technically, or to classify these groups into four broad categories, we have the business partners or the business groups and investors, which are one set of special disputes which the people face. There are joint venture partners, there are co-developers, there are builders who work with you as business partners. The second segment of people who are in disputes or who are in business together are lenders. Infrastructure contracts generally face lender issues, and there are a lot of questions which come of how to handle these lender challenges. I think the third and one of the most important and complicated segment is the state and state entities. A lot of people here will be involved in PPP projects, and the unique challenges which come in from a PPP base are and have to be handled in a different way. And I think lastly and more importantly are the contractors and suppliers, which is the daily disputes we face in the EPC scenario, in turnkey scenarios. And I think today the purpose is to take Mr. Mukhopadhyay's view on all these four categories. And I think with this I will move on to you, sir, with my first question of the day. So common disputes, I think, between business groups in the first category, which is lenders and business partners, and they face unique challenges. What are your views on the disputes faced by these business partners and investors in infrastructure sector?
There's a huge number of disputes which are happening between lenders and the business partners or the companies which have taken the facilities, and they arise from really various circumstances. One is, of course, the fact that sometimes the lenders accuse the promoters or the companies of having siphoned funds, for example, diverted funds into different other projects rather than the project for which the loan was taken. Then you have disputes which arise simply because some PIL has been filed somewhere and the whole project has been injuncted in an ex parte order which has then stayed for years. And what does the lender do? I mean, it's nobody's fault. Those guys are trying to fight it in court, but the lender is not getting any payment, the project's not taken off. Disputes start between them. So the wide range of disputes that you see on a daily basis which arise in infrastructure projects, particularly in the Indian context.
I think a good point which you made was lenders facing special issues, and I think one common question which always comes to the lawyers is that if I am from the lender's side, do I use my SARFAESI remedies or my invoking my security remedy, or should I go to arbitration? What's your recommendation on this?
I think a lot depends on the fact of each particular case, right? If you find that if a lender, I mean, looking from a lender's perspective, if the lender finds that, look, this is the management of this company is really doing things which are unacceptable from a lender's point of view, then I think SARFAESI is the answer to it. Another reason for SARFAESI probably is that, arbitrations in India compared to arbitration, you're not certain as to how it's going to go, what kind of a tribunal you'll get, how long it's going to take. You might get the award, and then how long it's going to take to enforce the award, depending on which court, because we have such a wide variety of court structure. In some cases, like in Bombay, Delhi, Calcutta, small jurisdiction, Chennai, you have original jurisdiction in the High Court. Or other places, you might be in some, small court somewhere else, and from there to right up to the Supreme Court, the battle is going to go. even in the High Courts, I don't know how the Bombay High Court fares, but for example, some people say that Delhi High Court, calendar-wise, in terms of the workload, it's worse in the High Court than in the trial courts, because you have fewer judges and much more number of cases compared to the trial courts there. So you have looking at all this. I think Sarfrazi probably, I mean, if they want to take over management in particular, is obviously the answer.
And I think
but
the
if
new
it's simply a question of recovery of some amounts or something like that, or getting them to act in a particular way, then arbitration might be better.
I think now even the provision where they're allowed to change into the shareholding of the company, the new RBI amendment coming in, may be affecting the Sarfrazi route. So at the same time, I think Supreme Court had come up with a judgment in this connection in Booz Allen, where they have given a very interesting twist, putting in general that rights in rem cannot be arbitrated. Now, when it comes to lenders, and they are always going to enforce security, which in effect will be a right in rem if it's a mortgage. What do you suggest on that? Do you think there's a way out to it?
Well, the way out is given in that, I think, the Tata Capital judgment, in a sense that if you choose to enforce the mortgage, that is, you want to, because that's an action in rem, what the Supreme Court said is you can't go to arbitration. But in the same judgment, they did say that if you're just simply you're not going to enforce the actual mortgage itself, but just going to enforce the right to recover dues, etc., without enforcing the mortgage, and that would still be in personam, and you could go, to arbitration. And that's what happened. I think the Bombay High Court in the Tata Capital case dealing with the Section 9 petitioning for interim relief said that, look, merely because there is a mortgage on the property doesn't oust the jurisdiction of the tribunal. It depends on how you fashion your remedy. And I think this also arises a lot when we come later maybe to questions of company law versus arbitration.
Right.
It's a question of fashioning, how you fashion the remedy that you seek. You can fashion it in a way that stays within the jurisdiction of the arbitral tribunal, go only for the contractual rights, not the mortgage right. The moment you go into mortgage right, it's in rem, and therefore you go into the court. I'm not so sure also whether actually Booz Allen is absolutely right in that sense. There's a paragraph in there which in the first 3 lines actually contradicts the next 2 lines in some, in a way. You talk about, let's say, that paragraph I think refers to specific performance of sale agreements. And in the same paragraph then it talks of mortgage. Now in a sale agreement also you have, the concept of lis pendens really applies when there is a suit filed and you don't need to implead other parties because there is lis pendens.
Right.
Now, does that apply to an arbitration? So, I mean, but the court says, well, sure enough, you can go for specific performance of an agreement to sell to arbitration, but you can't go to, in a sense, perform your mortgage because the CPC gives a whole series of sort of provisions as to how to deal with a mortgage suit, etc., and what is to happen in those mortgage suits. So, but as the law is developing, I think the court is getting more and more arbitration friendly. It might change its view even on this sooner or later.
So I think the message you're trying to give is that you need to strategize, you need to see what goes to arbitration. Maybe it's quicker to finish some disputes through arbitration and then knock the court's door for enforcing the security in your hand.
And one of the things I think the lender, if it's going to enforce, will have to see is what are the complications involved. If there are multi-party situations, then obviously a mortgage suit would be much better because you take care of everything in one shot. If you think it's just the two of you and you can manage with a contractual dispute, you can go to the arbitration, which might really be much faster than a civil suit in Indian.
So I think the one very important drawaway from this is that you crease out the objections which go into court, because I think one thing lacking in strategizing arbitration is today you take a step, but you don't realize what arbitrability issues are going to come up, which eventually you have to curse that my dispute got delayed because 2 years I was actually fighting arbitrability.
Except that in the genius of the Indian defendant always finds some issue of arbitrability even where there should be none. So they find some, and then you never know where it's.
I think with the likes of you defending the claimant on that side, I think that can be thrown out of the window. I think with this I will move to my next question, and I think a very relevant one. A lot of people have spoken about, and I think a lot of people here have attended conferences on expediting arbitration, on how arbitration process to work. But the question arises, what do we do when it comes to a PPP project? Because the government won't agree to an institutional arbitration. They will still have their engineers sitting on it. There will still be a question of bias which comes in. What is the key strategy to avoid this in a PPP dispute?
Well, I think the court had a good opportunity in that Raja Transport case, which they sort of threw away. because I firmly believe that all these clauses we have, I mean, literally every public sector contract clause here has a clause which says there will be no objection if the employee is an arbitrator, etc. Raja Transport made sort of a bit of an inroad towards a bit of, by saying that if a person has dealt with it or his superior has dealt with it, then he'll be disqualified despite a clause like that. But that's not enough, I think. I think we have to go far away. I think, but that may be answered if there is, the Law Commission is looking at amending the Act, and they are planning to bring in, if it goes through, that is, and if the government accepts it, because this is obviously going to affect the government the most, a whole sort of who can't be arbitrators kind of thing, which includes.
And I think yesterday you achieved that to some extent when you got the judgment from Justice Nijjar in the Kishan Ganga arbitration case. So tell us about that, because that was the PP project.
Yeah, I'm not involved in that case myself, but I was following it closely, of course, because it's an interesting issue. It's PPP project. It's and it's interesting because obviously there's Reliance and there are those other companies which are foreign companies who have invested into the project, and on the other hand there's the government. The question really arose as to whether the chair, and both of them had appointed, interestingly in this case, both the parties appointed former Chief Justices of the Supreme Court as their nominee arbitrators. But when it came to the question of the chairperson or the chairperson of the tribunal, I think one of the arbitrators took the view that it must be a independent national, in the sense that nationality of neither of the parties of the who were contracting parties in that particular project, which meant that the what he was saying was you couldn't have an Indian national, you couldn't have a Canadian national, you couldn't have an English national, and you had to look for something outside of these nationalities. And of course, I think Anil Diwan, Salve had appeared for Reliance, and I think Anil Diwan appeared for the government of India, saying that both parties are Indian, it's a completely Indian kind of circumstance, so you should have both the two arbitrators are Indian, so why should the chairperson not be an Indian arbitrator? But I think the court did take a good, I mean, in my view at least, the right and global perspective that, look, whatever this tribunal is going to decide is going to affect the investments of the foreign entities also, although they are not directly parties to the arbitration. And even the section in the Act says that in international commercial arbitration, the court should strive to appoint a neutral nationality chairperson. So I think it took that route, and I think that's the right development of the law to select somebody, and I think it chose somebody from Australia to be the chairman.
Right. So I think the point which comes next from what you just said is the Supreme Court recently giving a lot of good judgments. Of course, the Kishan Ganga arbitration being one of them, and recently in Jan there was the MSM satellite judgment. Now, people in the real estate sector and in the infrastructure sector always has this one question that I have been defrauded. And then when they come back to the lawyers say that, but fraud can't be arbitrated in Indian law. And then there is a complete question on the face that why can't fraud be arbitrated suddenly? Because it's there in the Contract Act. So what do you think about this development, the exciting development of MSN?
Yeah, MSN is definitely sort of developing in the right direction. Only thing is the court was in a difficult situation because it had a sort of coordinate bench decision of an earlier Supreme Court judgment in a purely domestic arbitration, which had said that you can't arbitrate issues of fraud. Now, that was surprising if you ask me, because right from the 60s, the Supreme Court has been taking a view that even under the old Act, that and this is a much more sort of liberal Act in that sense, the 96 Act, that where questions of fraud arise in an arbitration, it's up to the defendant, the person against whom fraud is sort of alleged. If he is willing to go for arbitration, there's no problem in arbitration. It's only if the person who is the defendant who feels that, look, my name is being sullied and I want that decided in open court because I'm a perfectly good person and I've not committed any fraud, that it wasn't, to go to arbitration, and you would exercise your discretion under the old, the old
and
Act.
Which got removed in the new Act, absolutely.
So Maestro, which is the judgment which said that fraud couldn't be arbitrated, was clearly wrong in my view. MSN could have,
gone a little more ahead.
And sort of referred it to a larger bench and got it settled once and for all. But that didn't happen. But because it was an international arbitration seated outside India, the court said anyway it doesn't apply to international arbitration. Therefore, there's nothing in fraud not being arbitrated, and we'll send it to arbitration.
So I think it clears at least the area for international commercial arbitrations, because institutions like ICC is sitting on arbitrations and their awards are being challenged because some fraud has been found out, and the irony of the situation is the person who's the defrauder can actually come back to India and say that the award is against public policy.
Correct.
So I think it's a very positive development from that angle.
And in fact, the Supreme Court did cite that judgment, but the Fiona Trust case, which went to the House of Lords, that's even held that fraud in the sort of entering into the contract itself can be arbitrated, not just fraud in the execution of the contract, but even whether fraud induced the entering into the contract can be arbitrated, unless the arbitration agreement itself is sort of impugned for fraud.
And I think by MSN putting the limited criteria out, it would also cover the situation of any kind of fraud under Section 17 being arbitrated.
Actually referred to with sort of approval.
Right.
To Fiona Trust, which is, of course, the House of Lords judgment is called something as NAFTA something.
Right, right. I think my next question is connected to fraud, and I think for the infrastructure sector, it's a very important question, which is corruption today. Today, there are a lot of questions that you enter into a project. You have taken the project, you've joint ventured in the project, you've invested in the project, and suddenly the project land is gone because there is a litigation going on for a quid pro quo against the initial promoter. And or there is some tender which was not done properly, or there was something not done how you didn't want it to be done, and suddenly after 2 years in the middle of the project when you invested money, you have allegations of corruption. Now the minute you come to a lawyer, the advice is don't arbitrate this, it's corruption. So how do you deal with corruption when you have arbitrations?
Well, I think that's again coming back to fashioning a remedy. I mean, if you go to the lawyer and the lawyer advises you, okay, go full on with corruption, the tribunal will get prejudice against the other side, and you'll get a resounding award in your favor. You might just be making a mistake because then the other side has a public policy objection to the whole thing. It's not capable of settlement by arbitration because it deals with corruption. So you limit your sort of remedy in the arbitration to the contractual side. That is to say, simply it's a breach of contract. Even if you can put it to fraud, but it's essentially a breach of contract in one form or the other, which gives you the right to damages. So limited there, of course, preserve all your rights. If you want to go for corruption into the, whether you want to go to the criminal side or something like that, that's a different matter. So there's nothing wrong in arbitration continuing on the one hand, and even a criminal complaint, just like a civil suit can continue with an criminal complaint.
Well, that's an interesting point, but do you think that by initiating a criminal complaint in the middle of an arbitration, you have issues which will come into the defense not giving documents, calling them self-incriminatory, because you're suddenly in a criminal proceeding, you have a discovery order which comes in from an institutional arbitration, and you can't discover because there's the defense of Article 20 available.
So do it after the discovery. Go through the discovery phase. Once you've got all the discovery documents which establish your case of fraud better, then you file your criminal complaint.
So I think the key again, the drawing point is strategy, and I think that is the talking point of the day, that strategizing an arbitration is much more important than going into it and starting it.
I think strategizing your arbitration starts from the choice of your tribunal itself. I think every step of an arbitration is part strategy, part proper advice on merits.
Right.
And particularly in India, if you don't get your tribunal right, you could be stuck. I'm doing an arbitration right now, which is, I came in very recently into it, but the history of it, it's now 14 years. 1999 it started, it's 2014, it's still on. So if you don't have the right tribunal, you can be stuck really badly.
I think even before you get a tribunal, I think even the notices is where sometimes you see that GCs have already taken a stand. By the time you have a chance to even call for a default, you've already taken a position in your arbitration, and it becomes quite challenging. I think the other important topic, which I think is more regularly faced, is the day-to-day disputes which come in. When you're doing an infrastructure project, there are going to be areas where the construction has not happened properly, there is a delay, the costs have gone up, and costs going up in India is there's always a defense that, there has been an economic downturn which has affected my costs. So how do you think how to handle these supplier and builder contracts?
I think the most interesting disputes are these sort of, owner and contractor disputes, because that's not the end of it. There's always a contractor and subcontractor dispute. And if you're acting for the contractor, that's when you have the real problem, because, you take a stand against the employer, saying, let's say, for example, you take a stand, you've not delayed, right, in the project. And in the meantime, the subcontractor has started proceedings against you, and you want to take a stand against him that he has delayed, but his delay means you have delayed. So it's really always a challenging, sort of balance. How do how exactly do you advise a contractor who's come to you as against an employer? It's easier when you're advising an employer. But the only way to do these disputes, I think, is which is developing is you have these multi-party dispute sort of systems where you can have consolidated arbitrations, one back to back or whatever, so that, and possibly the same tribunal, so that you can solve everything in one go.
So I think the 7-trend judgment will definitely help, the chloro control 7-trend judgment.
That's also a wrong judgment. I think it went in the right direction but went overboard. I think
but as the law stands, I think that would really help people who are in infrastructure disputes to take in people in the party, because effectively the subcontractors signing the agreement to do the same work as the contractor is. So, but at the same time, in disputes with contractors, do you think keeping an expert panel right on day one is because it's a business dispute? I don't need to go into arbitration for issues like delay and cost. Can I take an ICC expert body and tell them that you're going to act like a dispute panel, or I can pick up a few guys to act like experts in this?
This dispute resolution board kind of thing, which FIDIC, which sort of is very standard in the FIDIC concept. I don't think it works in India for some reason. I've never found it really being useful, except where in some cases where we actually seen the employer and the contractor decide that, look, this is the way to do it, but they don't want to do it in a settlement because of obvious reasons, so they do it through a dispute settlement board. But when it's a genuine dispute which has to go, I've hardly ever seen a dispute settlement board actually solving the problem and it not going to arbitration finally to be resolved.
So is the problem in mindset, or is the problem of...
It's, I think, a problem of mindset. I think it's a problem of concepts of fairness. I think, where as people have matured in other jurisdictions, I think the dispute resolution boards, even though they are appointed by the employer in many cases, they're still very independent in the way they approach the dispute. I think most of us lack that kind of independence. We feel an allegiance to the person who appointed us, and things like that. That mindset, if it doesn't go, these dispute resolution boards are not.
So do you think getting an institution right there, maybe getting an ICC dispute board, would solve the problem? Because in the end, you don't want to fight in an arbitration for every delay which happens.
Yeah, you could if you agree to that, but whether you're going to have a state, particularly state employers, agree to a sort of ICC board or not, these are difficult.
But I think if you're with a private guy, day one, it's a good choice to take an
then it's a very
board.
good choice. It might just help you a lot in getting a lot of cost saved in a large arbitration, a lot of time saved as well.
And especially when you're doing bigger projects, it's only one phase which is disputed, but the other 4 phases construction is left, and you don't want to lose the tender going into an arbitration. At the same time, sir, I think one very good point which you made right at the beginning was siphoning of funds. Now, this is one typical scenario which comes into every Indian dispute. Even if you've not siphoned, there will be an allegation of siphoning. If you have siphoned, there will be objections of going into arbitration, and there will be a problem of non-parties, because especially when there is siphoning, the people who the money go to are nominees of the person, and you can't bring them to arbitration. How do you deal with siphoning? What's the best way?
Well, I think you can deal with them in arbitration, and I have done a few arbitrations where we've actually been able to establish the siphoning of funds and been able to get an award directing the repayment of those amounts. But of course, the funds have gone into third parties, as you said, relatives of the promoter, whoever it was, the joint venture partner in that case. But I think at the same time, of course, there are other remedies available, like the company law board, for example. If it's a joint venture company, you have 397, 398. You can go for other things like malfeasance, etc. But you can do both at the same time too. I mean, if you again fashioning a remedy and say you strict your contractual rights in arbitration so that you get a result for the damages and recovery of the amount that you want to, or also directions as to how the company is to be managed in the interim. Of course, even directions for transfer of shares, possibly just like you do in 397, 398 also. But you can do malfeasance or actions like that in order to make sure that it's not repeated, at least in the company law board at the same time. Of course, when the new act gets totally notified and the NCLT might have exclusive jurisdiction on such issues, then another problem is going to arise in the arbitration world on these aspects.
Right. So I think this gets me to my last part of lines of question, and I think which is the new word, I would say, bilateral investment treaties. And all the media channels are talking about it. All the especially the infra guys are talking about it. Recently, the Maldives issue, the question came in whether India has a bilateral investment treaty with Maldives. What do you think? What is your view on BITs and how does it impact the infrastructure?
Well, looking at the what's been happening, I think BIT arbitrations are the thing for the future for all the arbitration practitioners in India. I think it's a development which is going to go for quite some time. There are a lot of issues which do arise in BITs, and I think the government understandably is taking a view that they are in the sort of the backside of it, and they are going to get the backside of it. Not necessarily so that they will get the backside.
Finally, the government has a backside.
Yeah. but it's a very different branch of arbitration. For those who haven't experienced it, it's not your normal commercial arbitration which happens where you have simple contractual disputes. Issues which arise in a bilateral investment treaty arbitration are very, very different, and unless you are or have some experience in those kind of arbitrations, it's very difficult for you to actually manage it. So I think both India as a government also is obviously now hiring international lawyers to handle it for them, and most of them are led by international firms which have had the experience. But it's going to be a challenge also in terms of enforcement of awards sooner or later when the larger number of awards came. One, of course, we all know about, I think, is the White Industries one, where they didn't need to enforce it because the government paid
settled up. Eventually, right?
Settled it. So it didn't need to pay it up. But that case is still actually pending in the Supreme Court. The appeal is still pending. Although
so I think with Balco
it was part of the Balco, but what Balco did was only decide the issue
and defeated them eventually.
But we've got notice issued on 197.
Right.
That's an interesting thing. In the Venture Global Part 3 now, Venture Global 1 was following Bhatia and said 34 will apply to foreign award, literally. Venture Global 2 was the question of the pleadings of fraud and discovery of documents and things like that. So what happened after Venture 2 was that the matter went back to the trial court in Hyderabad for the setting aside action, actually the 34 petition, and the trial court set aside the award on the ground of fraud and RBI permissions, etc., for transfer of shares, which were to be done in that case. The appeal was filed against that, and the High Court reversed that. I had appeared in the High Court in that matter. Now, then the High Court, of course, we argued the point of 197, and even if it's prospective, why in this case it shouldn't apply, because we were party to Venture itself.
Right. And the Bombay High Court recently has said that.
In that mining case.
Mining case, right.
Yeah, exactly what Justice Chandrachud had held.
Right.
So, the court, of course, accepted all our arguments, but he said, I'm bound by Supreme Court, so we can't change it. So, although we won on the the award was restored, so we won on the merits of it and everything. So, the other side has filed, Venture has filed an SLP against that, on which notice has been issued. But we have also filed an SLP, saying 197 should be reconsidered, paragraph 197 of Balco should be reconsidered. And notice limited to that has been issued by the Supreme Court just about 2 weeks ago.
So I think so the interesting point which you brought is taking Balco and BIT in the same breath. And I think that's one major issue which I need to discuss with you, because the bilateral investment treaties are signed way back in the 1990s. They are continued to sign till 2010. Now, India has no legislation which governs bilateral investment treaties. Do you think our Arbitration Act is sufficient to maneuver such investment disputes?
Yeah, I think it is. And you see, the language of the New York Convention is broad enough because it says contractual or not, disputes which are contractual or not. So, this is a treaty dispute. It's not contractual in that sense, but still the language of 44 is wide enough. And even Vandenberg, I think, in his book does say, the sort of leading author on the New York Convention, he does say that there's no reason why the investment treaty awards would not also fall within the convention, New York Convention. Of course, where there is a specific convention like your Washington Convention, etc., it's a different matter. But other than that, there's no reason.
But then the question arises that if you bring it to a direct route and you're trying to enforce against India in India, public policy will always come down your throat.
Yeah, but I think what is going to happen in all this, see, it's rather young days for most of the Indian sort of defendant. You've had a lot of South American countries in bilateral investment disputes. The Indian awards are going to come in the next few years, I think most of them in the next 2 one and a half years, 1 year, 1.5 to 3 years onwards, all these 2G ones which have gone, etc.
The 7 2G ones and
so on and so forth. I think the government, if to the extent there are awards against the government, I think it's more likely that they would really not get into an enforcement stage, because there's always a reputational issue with the government, especially with India and its, and the stage of development that it is. For them to honor these awards would probably be more important than trying to raise public policy objections or not seek to voluntarily sort of honor them.
But I think the white industry has alarmed the finance ministry finally about the treaties which they went and shopped, and people have been coming with various interpretations, and
they didn't know the demon which was sort of hidden in them, the arbitration clause. But I think it's also quite for them to say that no, we must have arbitration in India or not have arbitration clauses in it is also not going to be acceptable to any other.
Exactly.
And why are we looking at it only from the foreign investors suing the Indian government? What about us? We are going out all the time nowadays. We are going out. In fact, if you read the papers nowadays, you get the impression that more investments, more big companies are investing outside India than in India itself. What about them? They're going to need the same kind of protections, from
and
those.
GMR famously didn't get the protection.
In Maldives, they don't have a protection because we don't have a treaty. So, I mean, why don't you think about our own industries which need that very protection which, you're giving to the foreign investors. Similarly, that government is going to be giving to our investors.
I think that's a good point, especially with Indian investment in Eastern Europe being so high and the present tensions of war in Eastern Europe. If I had a bilateral investment treaty, a war situation would have covered my investment, but today with nothing. But do you think with that, India should reconsider its position on the Washington Convention? In fact, when the Washington Convention was signed, India was one of the first members to make that draft and to get in people to join that. But then India eventually never signed it. So what do you think India's stand on the Washington Convention should be?
Well, I think sooner or later they have to take a policy decision on it. I've really not thought about whether we should sign it or not sign it. The main thing is, as long as you have investment treaty, or treaties with the main countries in the world, and which have provisions for arbitration, whether it's in ICCL or whether it's, if you sign it, it'll go ICSID. I think you're on good wicket. So since we by now have quite a few treaties, in most of the really developed nations have treaties with India. Most of them are pretty good, decent treaties for investors from outside India too. So I don't think we are very badly off without having signed the
so we are covered from outside, but when we go outside, we're not covered in any of the smaller African nations or any Eastern Russian nations, and so I think that's the area of concern.
I think, and we should look to remedy that situation so that our business houses can feel safer in investing in foreign countries, where in fact there are greater problems of this nature, expropriation and things.
Right, India was never ever, anyone thought that India could face a BIT claim because we were known to be the fair ones, but I think with corruption opening doors into BITs, the debate is...
I think the 2G judgment started the trend in a big way.
Right, so. Right. I think, sir, from this I take two talking points to the audience. Number one is when you are in your domestic disputes or international disputes, the key is strategy. It's not that you march into your dispute. Generally we've seen the trend that you first dispute and then you think. I think when you're in the infrastructure sector, the key is to first think, to strategize, to build that paper trail and then go into disputes. Look at options like BITs when you are in a foreign dispute. You may be having a foreign investor in your project who may be protected if not you. That route is exercisable to take your PPP projects. And I think one last key was, be it fraud, be it siphoning, you need to ensure that you go in the right way, even if there is a suggestion from a lawyer that take allegations which will prejudice the court. Make sure that you don't get stuck in the tussle of arbitrability, because instead of arbitration, you will be spending a lot of time in courts.
And jurisdictional issues.
And jurisdictional issues, trying to resolve those in courts and cursing the long time it would take. And I think with this, I'm going to leave it open to you guys to ask questions to Mr. Sikku Mukhopadhyay. Anyone?
I think over the last 1 month actually, we've seen 2 or 3 cases where the mandate of the arbitral tribunal has been terminated here and there. One is 14(1)(b) terminations by mutual consent, and the other is an arbitral tribunal terminating its own mandate. Now, I don't think the latter is even permitted under the Act, whether an arbitral tribunal can terminate its own mandate, maybe an arbitral tribunal. And as for the former, I don't know if 14 is set aside. What do you think?
Yeah, I think taking the former one first, the one you're really talking about is the Delhi High Court one. I think that although the order says that it was like by consent they mutually terminated, but really it was the judge telling them that, look, if you don't, I'll have to do it, kind of situation. But what happened in that case was that a number of hearings and a huge amount of fee has just gone on the jurisdiction issue before them, and they felt, and it's a high-powered tribunal, retired Supreme Court judges, etc. And obviously the court didn't want all that coming out in a long judgment with all the names, etc., or something like that. So I think the court did the right thing to sort of persuade the parties themselves to agree that they would terminate the mandate.
Yeah, I think Justice Vipin Sanghi has done this before also.
I think Justice Muralidhar had also done it before, and Vipin Sanghi has done it in one or two other cases. I think not too many up till now, but one or two definitely, and that I know of. Maybe there are more.
But if I may add to this, I think the mandate law in India is one thing which is a very interesting scenario, because unlike many countries, we have the only place where there's a provision to fix a time, and if you fix the time and don't do the dispute within that much time, your mandate expires, and that drives the tribunals at times to finish the dispute in that much time. And
that's a very important point, actually. I mean, just to answer the second question on the question of whether the tribunal itself has a power to terminate its own mandate, you're right. I don't think they have that power, but they effectively do that power by just, if they all resign, it goes. The 14 doesn't talk about, but 14 does say that when you resign, your mandate terminates. So, in a sense, they unknowingly or knowingly did that by saying that
But my remedy would change, right? If I was the aggrieved party, my remedy would change. If you would terminate his own mandate, it's an order that I need to challenge. If he resigns, I can just appoint a new arbitrator.
Yeah. That's true. That's very true. But even if the mandate terminates, you can still appoint. You see, because 15 takes care of that, right? If a mandate terminates of any arbitrator under 14, 15 says he has to be appointed in the same manner. Like you can appoint an arbitrator in the same manner. So even if you'll actually effectively they've really resigned by terminating the mandate. I mean, if they had come to a decision that they have no jurisdiction, then it's different. Then you would have an appeal under 37. But they haven't. In this case, they didn't do that, but they just terminated their own mandate because of the parties,
But then
conduct.
exactly, right? So Lalit Kumar Sanghi finally concludes that I think they need to challenge the validity of the order.
But there is no, see, one of the things is I think the Act doesn't have a provision for challenging the validity. What kind of order is that?
Exactly.
You see, it's not an award. Because if you had held we have no jurisdiction or there is no, cause of action or something, then it's an award. Terminating a mandate is not an award, it's not an order which is appealable under any of the provisions of the Act, because even an order passed under 14 by the tribunal is not an appealable order. Even if, for example, you
unless the controversy remains unsettled, which
but even then it's not an appealable. You see,
you can go to the court
and then the court will decide it. So here they've themselves terminated. So effectively you would say they've resigned, and therefore you would say that I have the right to nominate new arbitrators and sue them for their fees.
I think you'll have an answer in
sue them for their fees, because the Act says that if it terminates and you have a problem. You see, if arbitrators start getting sued for the extra fees that they are charging, and some of them are charging phenomenal fees, you will have, I hope they don't hear me saying it, but you'll have a different kind of circumstance, I think. Yeah.
I think you'll have an answer in a few months, because we have a similar situation where we've now said that the order under 14 is actually a jurisdictional order, because there is no procedural way to make that application of the mandate.
Correct.
The only provision you can make an application of mandate is 16. So if that works, then you have the 30-day limitation which will tag along with the arbitration. Any other question from the audience?
On this very point that you had raised, one of the amendments which in this new Act, or the amendment to the Act is being proposed in 14 to add a provision that if a tribunal doesn't render an award within 2 years from having been fully constituted, then that itself would qualify for that delay.
So there's a statutory period for doing an arbitration.
So instead of having like 4 months where you've already gone, but here at least the parties have the option. If parties want to continue with that tribunal and they're happy to go on and waste time.
But then the question is whether it will be derogating or not derogating, because then if you keep a 3-month period, am I going to still get the 2-year extension? Because if it's not a derogable provision of 14 and the statute puts a number, Indian courts can take it to a tussle and say 2 years no matter what happens. You can sit on it for 2 years and charge fees.
No. I hope that's not what the arbitrators are going to do, because I think it should be like a sort of sword hanging on them that, look, we should try and finish it as soon as
and also get some seriousness that there is actually the statute who's telling you to move quick.
I think the way they have to go is to adopt the sort of, and I'm sure Simon, when he's here, can tell us more about that, is that to adopt that system of a procedural timetable, fix things in advance, fix the dates, tell them this is your time. You're not going to have endless days to argue your
Right.
your side's case. And that's it.
I think Abhinav had a question.
Yeah, I have a question, but I'm not very sure there's a straightforward answer. Pratik raised a
I
very
can expect that kind of question.
Pratik raised an important question about corruption. Now, what in your mind, if there's an international commercial arbitration, of course it would a lot depend on the applicable law involved in the dispute. What are the ethical duties of an arbitrator? Were he to find that the award was tainted by corruption, would he go on to render the award? Should he complain to the Bar Council? Should he, what should he do? I mean, he finds that right at the end in a hearing where one of the witnesses says, I paid the government, or there was a kickback. What do you do? What happens to that kind of a scenario? What should the arbitrator do?
I think the ICC just came with a bulletin on that, right? I mean, I think that's let's say if I were an arbitrator, what would I do? I would go and do both. I would make the award the way I feel it should be made, and then, make the complaint wherever I think it should be. But then, are we breaching the confidentiality provision of the arbitration? I don't think it applies in these kind of situations where you know that somebody has.
The public policy concern.
Yeah, the public policy concern.
So do you think the mandate of an arbitrator, the public policy takes the confidentiality versus public policy? You think public policy overrides the confidentiality?
I think there is a stage where it does come. They will, I think it's you're going to always have to weigh the scale. Now, if like you said, a witness comes and said, "Oh yeah, I paid the Prime Minister, so much or whatever it is of that, whichever country it was." But if you say that, if you're going to actually admit to corruption in that sense, bribery, but if it's something else, I don't know. Something which is vague or uncertain. He says, "Yeah, I paid. I paid some consultant. He may have done it. I don't know what he did or didn't do." It might be a different kind of situation. So arbitrator will have to take a call as it comes. And some of them will probably think confidentiality is more important than public policy, but it's going to be an individual choice.
I think Michael Wong has written very widely on it, and he's in the view of the latter, that you get up and you go and you complain, because that's where it.
I'll agree with that. Yeah.
And even IBI, I think, has been mooting this very, very strongly. I think a question right there.
As a follow-up to the question which was raised, in a situation such as, say, the Augusta Westland helicopters case, which involves an element of bribery involving defense subcontractors, there has actually been no bribe exchange between government official to government official, or at least such allegations might exist, but there doesn't exist much evidence on record. In that circumstance, would you say that there exists any objective tests to distinguish between the arbitrability of such an issue, wherein there are private sector consultants and government subcontractors, wherein there's an element of corruption involved?
Well, I don't know. Again, there are only allegations as now. Both, you can't say there is any sort of proved bribery or corruption as of
At least for the next 7 to 10 years.
Yeah, for God knows how long for that matter. But I think so. Therefore, I don't see a difficulty in an arbitration at either level in that situation today. And if an award comes before all that happens, then there won't be a problem. But let's say there could be a problem. Let's say midway through the arbitration, there is actually a finding of or there's really evidence which is so strong that it's unrebuttable kind of evidence that there is bribery or something like that. That might impact an arbitration at both levels then, even if it is at a lower level, because ultimately, obviously, that subcontractor has been used in some way or the other to be able to procure the contract. So it might affect it.
And also I think one very important point is raising the allegation is okay, but at the same time, the guy against whom you will raise the corruption allegation, his lawyer will definitely advise him to bring an arbitrability objection. So you need to be very sure, because though it's not eventually unarbitrable and it's effectively arbitrable, the minute you start using words like corruption and criminal misfeasance, and there's always this risk you're running that there will be an objection which will take you to court and which will stop your arbitration. So I think strategically thinking of how to approach this is something which is very important.
Yes.
Okay.
Something you said that caught my attention, and I'm not sure you were allowed to complete that. Why do you think fluoro controls went to court?
Okay, good question. See, if you see Chloro, what happened in Chloro, let's go to the facts of that case, okay? There were various agreements some of which had an arbitration agreement, some of which didn't have an arbitration agreement, some which in fact had court jurisdiction. Right? No arbitration agreement, not silent, but exclusive court jurisdiction. Now, you have a what the court called the mother or principal agreement, right? Now, which is between two, let's say, joint venture partners. Now, as a result of that agreement, you may have a number of ancillary agreements. Now, a dispute which arises in connection with that agreement may be arbitrable under the mother agreement itself, not those agreements. Why? Because this agreement does contemplate that very agreement to come into force, and your arbitration agreement is wide enough because it says in connection with, arising out of this agreement. So there can't be a doubt that that particular ancillary agreement arises out of this. But that doesn't mean that you can bring into that one arbitration third party or arbitration agreements which have a completely different clause, a court jurisdiction clause, because if you've opted for a court jurisdiction clause, then you're opting out of arbitration. So, but although this dispute between the two parties in that is would not necessarily have to be brought under that agreement. If you raise the dispute under that, the separate agreement, then you have to go to that court, in my view, and it couldn't have been brought in here. What had to be done by the parties there, or the party invoking arbitration there, was that, look, all these disputes under the ancillary agreement between the company, the joint venture company, and one party or the other, are all disputes which have arisen in connection with this agreement. And you make your rights and obligations, or fashion, again, it's a question of fashioning the claims that you have in a way which comes within the principal agreement, so that you don't have to go into multiple disputes under different. Toro went too far by putting all those contracts and saying that, look, all disputes under each of those agreements will be arbitrable between all the different parties. So what you have done is brought into one arbitration maybe 8 or 10 different parties, some of whom never contemplated arbitration at all in respect of that particular dispute. And what it did to do that, it interpreted the words in section 45, or the party and a person claiming under him. Now the word person claiming under that party is a very narrow thing. You might have an assignment. That's a person claiming under the, you might have a situation where there is a successor in interest or something like that. The original arbitration agreement is with party A, that company has merged into another company, but that, it's got transferred, so therefore that party is claiming under the original arbitration agreement. It doesn't mean a party who is a third party, completely unrelated, or, in that sense, unrelated meaning a distinct entity, who's got its own agreement with some other, with one of these entities, is not a person claiming under that party.
But unless the court would have done that, wouldn't the judgment under those exclusive jurisdiction clauses create res judicata?
But if the parties have chosen those, if the parties have chosen to create chaos from themselves, what can you do? They are. One of the things which I don't understand is, as lawyers, when we advise, and you have a string of contracts, I've seen it happen so many times. You have different arbitration clauses. You'll have arbitration clauses in 5 contracts. All of them are different, or 3 3 of them are different. What's the point of that? Why are you doing that? It's just a remedy for disaster. That's it. But if you've done it, then you must live with it, so that somebody in the future will not repeat it. Because if you do this, what Chloro has done, then people will start doing that in other contracts, and then hope that Chloro will save them, by which time some other bench might think that that's wrong. And in fact, in one of my cases which came up shortly after Chloro, in the Supreme Court, came from the Delhi High Court, and the judge did remark that he thought Chloro was wrong, and he wanted to actually refer it, but we could manage to get out of it by keeping it on a much narrower wicket, because otherwise it would have been stuck in the court for another 5 years, because 3 judges to 5 judges and all that. Right.
But Chloro has helped to some extent when it
does
comes
help.
to
It's
directors, promoters getting into an arbitration.
Yeah. I agree, it's very pro-arbitration in that sense. But as a matter of pure law, I think it's wrong.
So I think the point is not being pro-arbitration bias, but being pro-arbitration and not going towards jurisdictions like Singapore, where I think there's a notion now being spread that there is pro-arbitration bias instead of the other, where in India there was an anti-arbitration bias. So I think that balance is what is required in the judgments which come in.
One follow-up, but in premium NAFTA, Fiona Test, I'm not sure which of those.
The same thing. Fiona Test, when he went to the Supreme Court, became a House of Lords. Yeah.
But there's a paragraph which talks about the business interests and the business ideas of the parties, where it says that when you're interpreting in connection to a arising out of this agreement,
Yeah.
you should be keeping in mind what the parties had in mind, and the parties couldn't possibly had in mind exclusive jurisdiction on one side, arbitration on one side, court on one side. It's probably them not understanding, and that's what you should keep in mind when you're interpreting something like
Yeah,
that.
absolutely. Yeah.
So then in that context, we shouldn't even be reading it only for legality.
No, it's not. I mean, you have to read it in terms of, because after all, there's a section in your act, right? Firstly, I think one of the base problems that the court does in all these cases, they don't consider the law applicable to the arbitration agreement. In chloro control, did the court even go into the question as to which is the law applicable to that particular arbitration agreement in the joint venture agreement with an arbitration seated outside India, which is on the English law, whichever law it was, I'm not sure now, and
Right.
it was English law. So if the arbitration agreement is governed by English law, then you have to decide under that law whether
Right.
it is possible or not. I'm sure if that had gone to an English court, they would have said nothing doing, about the agreement which had the exclusive jurisdiction clause. You can't, those parties can't be brought into
And
this
Swastik has
arbitration.
now, so if you read Swastik and chloro together,
Yeah.
they'll never work
Then
because
won't work, yeah. So, I mean, first thing, they don't look at that. If you looked at that, you would probably find the right answer, and you would probably taken the old view which Sri Krishna had taken in what was that, which chloro in a sense overruled without overruling. It said prima facie view. If you see that there is an existence in arbitration agreement, you take a prima facie view. If the prima facie view is satisfied there is an arbitration agreement, you leave it to the arbitrators to decide, because they are the right ones who will know which is the law applicable to the arbitration agreement to
Right.
decide all these jurisdictional issues.
I think National Insurance then subsequently
Yeah,
affirmed
no,
that.
was that Shinetsu.
Shinetsu and then
But Shinetsu said that. But here they say you have to decide it finally. In chloro they said you have to decide it finally, whether there is an existence or not an arbitration agreement. And you're probably not the right or competent court to decide that in an international arbitration, in most cases of which, because the seat is outside India, at least the law governing the arbitration agreement is not going to be Indian law, which you're not familiar. Nobody's going to have nobody would have thought about leading expert evidence to show what is the effect of that arbitration agreement and whether you can arbitrate or can, interpret that arbitration agreement as widely as they've done in chloro. So it is an issue of law also, not just the intent of parties in that sense.
thank you
Thanks,
so much.
Pratik, for the opportunity to be here with.
Pleasure is all mine.